Recording. So, well, I'm seeing that people are arriving still. I might as well start so we have as much time as we want to talk about the issue at hand. Good afternoon, everyone, or morning, depending which time zone you are zooming in from. My name is Sarah Ferdman. I'm a staff writer and researcher at First Amendment Watch. First Amendment Watch is a news and education site based in the Arthur L. Carter Institute for Journalism at New York University. And this is the third iteration of our Fall Public Forum series, a monthly online Q&A and panel discussion where we talk to leading legal thinkers on the most pressing topics in First Amendment law. Today's panel discussion, Open Courts and Racial Justice, is co-sponsored by the First Amendment Coalition, an award-winning nonprofit public interest organization dedicated to advancing free speech, more open and accountable government, and public participation in civic affairs. As promised, we will be talking about how the pandemic has affected the public's access to courts in both good and bad ways, with a particular focus on the trial over the killing of George Floyd. This is, of course, a sensitive topic, and while the focus today is on public access to the trial, we understand that the stakes here go way beyond cameras in the courtroom. For millions of people who now have access to the trial, the questions get at the heart of public trust in our judicial system and government more broadly. Our guests today include David Snyder, the executive director of the First Amendment Coalition. David, who I will have to now refer to as David S. because we have two Davids here, is a media lawyer and former journalist for the Washington Post. This year, David S. has led a number of challenges to court closures during the pandemic. He was recently honored by the Society of Professional Journalists with the 2020 Freedom of Information Award for his work on open government cases and standing up for press freedom. We also have with us David Hudson, who is, if you glanced at his bio, truly a prolific author. He has written more than 40 books on First Amendment issues, including First Amendment, Freedom of Speech, Let the Students Speak, A History of the Fight for Free Expression in American Schools, and the 2-volume set of the Encyclopedia of the First Amendment. David Hudson is also the author of our newest teacher guide on court access, which was released today. You received that information maybe when you registered, and I think we've sent all the attendees a link to access that guide. But you can also download a free copy of it on our site. You can go to firstamendmentwatch.com/org by clicking, and then on our front page, click the instructions tab and then teacher guides, and it should appear there. You'll have to sign in and give some basic information, but it's free for anybody who's interested in learning about the issue in more depth. Both David and Jenny provided, our court access guide would not have been what it is without David Snyder and Jenny LaRoe at First Amendment Coalition. Both David and Jenny provided invaluable case examples, savvy edits, and discussion questions that will make even the most zoomed out students ears perk up. And finally, running out of breath, we have Leto Walker, who is a media and First Amendment lawyer in the Minneapolis office of the law firm Ballard Spahr. Lita successfully represented a media coalition in the criminal case against the officers charged in the George Floyd death. It is truly Lita who we have to thank for the level of transparency we've seen in this trial when the court wanted to impose a gag order preventing the participants in the case from speaking to the press. Lita helped convince the court to reverse this decision. She's also fought for the right of the press and public to copy and distribute body camera footage filed with the court, and convinced the state to allow audio and visual coverage of the trial. So without further ado, I want to open the discussion by looking at your work, Lita, in this last year. Can you walk back a bit in time and talk about how you got involved in this case?
Sure, and thank you. All credit really goes to the media clients who banded together to form a coalition and to really speak with one voice in this important case. And I think that's gone a long ways. But let me back up. George Floyd was killed at the end of May. And the immediate work for media lawyers like me was helping journalists who were covering the resulting unrest, many of whom got arrested, and working the phones to get them, released quickly so they could get back on the job, and then dealing with the aftermath of those arrests. But in terms of the criminal prosecution of Derek Chauvin and the other 3 former police officers charged in George Floyd's murder, my first work in that case started in July, when there was a motion to dismiss filed by Thomas Lane. And as part of that motion to dismiss, he filed the body camera footage of George Floyd's death as an exhibit. And the court, rightfully recognized that as an exhibit to a substantive motion, that should be public, but it put restrictions on how it could be accessed, saying it wasn't going to distribute copies, and it wasn't going to let anyone, make copies. But if you wanted to see it, you could schedule an appointment with the court during a pandemic, and you could come in and have up to an hour to watch it. And by the way, the videos collectively, there were multiple cameras, body cameras. And so the videos collectively ran for more than an hour. And so it was, completely unworkable during a pandemic to expect the national press to fly in to watch this. So we filed a motion to intervene and to get access, broader access to that, a right to copy, in other words, which is a pretty clear right under the First Amendment. And while we were briefing that, the judge also entered a gag order on trial participants, but was really very broad in the sense that it also gagged any employee of any attorney representing any party, which could be read to be any employee of the state of Minnesota, right? Since the state is a party to the case. So we intervened in connection with that as well. And the judge, thankfully withdrew the gag order, vacated the gag order, said from the bench he really wasn't going to rule on our motion. He was withdrawing it because he thought it was ineffective. Basically, he issued it and people still found a way to talk to the press about the case, which should say something about the effectiveness of gag orders, and then agreed with us that the body camera footage should be made widely available. I think he asked a question of the parties at the hearing on that, saying, is this going to be entered into evidence at trial? And they said, yeah, we're pretty sure it is. And his decision really turned on that. I don't know that that was the right analysis. I don't think it was under the First Amendment, whether it's going to be evidence at trial, but we got access to it. We got a right to copy it, and we were happy with that. Access issues came up again in October when there was another exhibit entered. This was also body camera footage, but it was body camera footage of a prior arrest of George Floyd from about a year before he died. There was again an attempt to keep that under seal. And the state also asked in October for sort of an automatic sealing on anything filed with the court for 48 hours, so that the parties would have a chance to brief why it should stay sealed. So we intervened and objected to both of that. We didn't get a written order on that, but the judge ruled from the bench that the body camera footage would again be public, and he wasn't going to auto seal anything. And that was really it, other than the kind of big issue we're here to talk about today, which is camera access to the proceedings.
Yeah. So we've all talked a little bit before, but in what way did the conditions of the pandemic really create the opening for something as historic as cameras access into this trial? And can you, when you talk about that, also talk about why Minnesota's laws make this even more unprecedented?
Yeah, it truly is unprecedented in Minnesota. Minnesota state courts, like a few other state courts around the country, do not typically allow cameras in criminal cases. Due to a pilot program for the last couple of years, there's been a default presumption that cameras will be allowed at the sentencing phase. So in the Mohammed Noor trial, another police officer who killed an unarmed person, and it was big news in Minneapolis until the George Floyd killing, You saw cameras at sentencing, but not at the guilt innocence phase. And that's because of Minnesota rules saying that at the guilt innocence phase, unless everyone consents to cameras, they're not allowed. And so the way this proceeds in Minnesota state courts is the media, really on its own without assistance of counsel, files a one-page form saying, we want to bring cameras into this trial. And then the judge asks the parties, do you object? And if anyone objects, that's normally the end of the story. This case has made strange bedfellows in a whole bunch of ways. But one of the ways was that typically you get the objection from the defendant. Here, the defendants wanted broad access, and it was the Attorney General's office that said, no, we do not consent to cameras. So like I said, normally that would be the end of the story. It lingered for several months, and then the judge issued an order in the fall saying, because of the pandemic, we're literally not going to have any spectators in the courtroom. And that's changed a bit. There are a couple which I can get into, but this is going to be trial participants only. And the only way I can comply with the First and Sixth Amendments, for that matter, is to live stream this thing to the public. And so that's what he said he was going to do. The state, the state at every turn has really opposed broad access to this, to my dismay, while at the same time saying publicly that they believe this is of utmost importance and they want the public to know what's going on. The state went so far as to file a motion for reconsideration in response to that order. And it was at that point that the coalition filed a brief in support of audiovisual coverage along the terms the judge had outlined. And it was not an easy decision for the press, because in sort of coalescing to what the judge was proposing, we understood we were giving up broad rights to be in the courtroom. But I think there was an understanding that even if we were to challenge that and to somehow force the court to move the trial to a different venue with more space where more people could be allowed while social distancing, we still weren't going to come anywhere close to having the number of journalists in that room as we wanted. And certainly nowhere close to the number of members of the general public as would be desired. And so, my clients, at least, I think, decided it was a decent trade-off to give up in-person access if they could have, live streaming in a way that's never been done before in the state. And so I think it was in November that the judge ruled on that motion to reconsider and stood by his decision, relying in large part on the media coalition's arguments. The way it's ultimately shaken out, that was issued at a time when everyone thought all four defendants were going to be tried together, in which case space was going to be really tight. If you think about four defendants, their attorneys, et cetera. Since then, the judge decided that Chauvin would be tried first, which opened up a bit of space. And so ultimately the people in the courtroom who aren't actually participating in the trial is the technician for Court TV, which is running the audiovisual feed, one print reporter who rotates among a pool, one broadcast reporter who rotates among a pool, and one member from the Chauvin family, one member from the Floyd family, and that's it.
Yes, it's one of these situations where the circumstances of that trial itself, its importance to the public, aligned with the factors or kind of limitations caused by the pandemic, basically created a situation which is truly unique. It's truly kind of unique both in Minnesota state law, but then also pretty unique in the larger scheme of how the public has been able to participate and experience a trial in a moment in time, and watch not only after months and months of protest and demands of police accountability, now a level of ability to see what happens when that kind of issue is presented in front of a court, and whether how it manifests or how it gets solved in a courtroom, which is traditionally, I think, in the American mind, something ambiguous and hard to understand or closed off. And in the pandemic has just been, to use a classic first moment, or just like there's been a lot of sunlight thrown at it. I want, just for the purposes of time, to move to David Hudson. David, let me scroll down. You just finished this teacher guide on court access. And this teacher guide is meant to provide this like really broad look at going back in time at how why the Constitution, why the First Amendment protects or ensures a reasonable public access to our court system. Can you help us take a step back for a second and understand what the founders have say about open courts and where this idea comes from?
Absolutely, and thank you so much for the opportunity. And it really goes back to the early English common law system. In fact, if we take a look at the U.S. Supreme Court's decision in Richmond Newspapers versus Virginia, which was, I think that opinion was released July 2nd, 1980, that's when the United States Supreme Court ruled that there was a First Amendment-based right of access to criminal trial proceedings, or at least criminal trials. And Chief Justice Warren Burger wrote the plurality opinion in that case, and he actually traced it back to before the Norman Conquest in the 11th century, and said that there were the right of free men to attend moors or moots and to attend court proceedings. And then through the 13th through 16th century in England, there was also a tradition of open access. There was a brief dark period with the Star Chamber, but I believe the Star Chamber was abolished in 1641, and we saw continued tradition of court access.
I explained very quickly for everyone what the Star Chamber is. I myself had to look it up, even though I've talked.
Well, that was a court of secret justice, and that was federal appeals court judge Damon Keith once famously wrote, quote, "Democracies die behind closed doors," which is one of my favorite passages. And essentially, the Star Chamber stands for secrecy and trying people in secret and depriving people of fundamental rights. And so that was abolished, and I think that was at least a significant symbolic event. And both Matthew Hale in the 17th century in his treatise on common law, English law, and then William Blackstone in his commentaries on the law of England both stress that there's a long-standing tradition of open court proceedings. That English common law tradition of open court proceedings translated to open proceedings in colonial governments. And we saw in Virginia in the 17th century, they had open court proceedings. The colony of West New Jersey in 1677 had a charter in which they talked about open court proceedings. And then the Pennsylvania Charter on Government, which was essentially Pennsylvania's state constitution in 1682, actually wrote in there that open government is part of an individual right. And so essentially both the English common law system and the system of what transpired in colonial America, this continued throughout the English system. And I think it was Justice William O. Douglas who wrote in Craig versus Harney in 1947 that what happens, that a trial is a public event, and what happens in a trial essentially is public property. And so the fascinating thing for the U.S. Supreme Court when they decided Richmond newspapers in 1980 is that there were a series of fairly restrictive cases for the press, Precuniae v. Pell, Saxby v. Washington Post, and Hutchins v. KQD, three decisions in which the U.S. Supreme Court held that the press did not have a right to interview prison inmates. And so it was really significant that the U.S. Supreme Court decided Richmond newspapers. And in Justice William Brennan's concurring opinion in Richmond newspapers, he said, look, the Constitution carries a gloss of history, that when looking at constitutional values, it's important to consider history and tradition. And what the U.S. Supreme Court also did in Richmond newspapers, and I don't think this gets mentioned enough, is Chief Justice Burger wrote that the right to freedom of speech also includes a right to listen. And he specifically cited a First Amendment principle called the First Amendment right to receive information and ideas, which is a First Amendment principle that's usually been traced back to Martin versus City of Struthers in 1943. And the idea is that, look, it's not just the First Amendment rights of individuals to attend, or the right of the press to attend, but it's also implicates the First Amendment rights of others to receive that information from the press. And it's a very important First Amendment right, the right to receive information and ideas.
Absolutely. I think it really doesn't get emphasized enough, this idea that the First Amendment is largely connected to the virtue of like self-government and our ability to participate in a democracy by both being able to speak our minds, but also by knowing how the government around us operates and what happens, so that when we make decisions, we're making informed decisions in our voting, in how we react to cases like this, and how much we know about them. But of course, in case with courts, there's this value or principle to ensure reasonable public access, but there's also a really important kind of guarantee of a fair trial. And sometimes those two things come into tension, which is, probably the first thing that people occur to as well. You have everybody looking, are people going to act differently in this space? Can we really ensure a fair trial? Can you talk about the limits and tensions of the right to public access, and maybe talk about some important cases that explain this?
Sure, be glad to. So, sometimes the First Amendment and the Sixth Amendment work hand in hand, right? Because the second freedom in the Sixth Amendment is the right to a public trial. So a criminal defendant has a right to assert his constitutional right to a public trial. There are other freedoms found in the Sixth Amendment, like the right to assistance of counsel, the right to confront accusers, the right to an impartial jury. Collectively, those are sometimes known as, referred to the fair trial rights of defendants. So in the 1960s, there were two really important, well, there were many important developments in the 1960s, but from a constitutional perspective in this arena, in the 1960s, the United States Supreme Court greatly protected free press rights, right? We got New York Times Company versus Sullivan, profound national commitment, debate on public issues, robust, uninhibited, wide open, and may well include vehement, sharp, and unpleasantly caustic attacks upon public officials, constitutionalized libel law. We got an extension of the actual malice rule in Times v. Sullivan in the Butts and Walker cases in 1967. And then we also got Time v. Hill, where the court essentially extended the actual malice rule in invasion of privacy cases against the whiff of a little-known lawyer by the name of Richard M. Nixon. But at the very same time, this time period in the 1960s, when the U.S. Supreme Court was expanding freedom of the press, it was also greatly expanding the rights of those charged with crimes. And I'm referring to the Warren Court, which is really from 53 to 69. But in the 1960s, we got cases like Mapp v. Ohio, where it extended the exclusionary rule to the states. We got Miranda v. Arizona in 66. We got Gideon v. Wainwright. And so when you have sort of an increase in the First Amendment rights of the press, at about the same time that you have an increase in the Sixth Amendment rights and other constitutional rights of criminal defendants, there was bound to be a clash. And there were at least three cases in which the U.S. Supreme Court actually reversed criminal convictions because of what they refer to as excessive pretrial publicity, or I think in the Shepard case, they actually used the term bedlam reigned in the courtroom. Three of those cases were Irwin versus Dowd in 1961, Estes versus Texas in 1965, and Shepard versus Maxwell in 1966. And all three of them are important, but Shepard versus Maxwell probably gets the most cultural attention because it involved Dr. Sam Shepard, who was accused of murdering his pregnant wife, Maryland, I think back in 1954, maybe it was. And he eventually was arrested and tried for that. And apparently the conduct of the press at that trial was the trial judge did not do a good job of controlling the courtroom. And according to Justice Tom C. Clark's opinion, essentially the press sort of overran the courtroom. And so those cases together, Irving v. Dowd, Estes v. Texas, and Shepard v. Maxwell, do show that in certain circumstances, right, that it's really the responsibility of trial judges to ensure that while there needs to be press access, it needs to be, reasonably restrained press access. So those are kind of important cases. That's not what the press does today.
Soraya, I was just going to insert, note the date of those cases, all pre-1970, the technology we have now. And I'm here to tell you, if you want to avoid a circus in a high-profile trial, you live stream it. Because I was at the Mohammed Noor trial. I was there on the day he was sentenced, and it wasn't live streamed. It was televised after the fact, not live streamed. The security to get in, people were riding up and down elevators because they weren't allowed on the floor because it was beyond capacity. This was pre-pandemic. It was a circus because people had to come to the courthouse to watch it. So I'll stop there on my bandwagon, but I think we're all of the same mind on that point.
I think there's two things there. So the first thing, which is so interesting in walking through the history as David is explaining, is that, of course, you're thinking about public access to courts, and then it works in tension with a fair trial. You have something, I think that David briefly touched on that. You have the First Amendment right to public access to the courts, and you have the Sixth Amendment right to a fair trial, which may sometimes include public access. A defendant may wish there to be greater public access in a trial because they perceive that as helping their case or having more witnesses to their case, which ended up being the case here. Many other cases, the defendant actually would prefer or motions to restrict cameras or press access to a trial. But as Lita kind of talked about in the earlier part of this, that was not the case here. You actually had the plaintiff, the prosecution wanting the case to be more closed off for whatever reason. And so just in the history, you're looking at that when the Sixth Amendment and First Amendment rights sometimes come to clash. Here they were working in tandem. And then you have the second aspect of David's historic lesson, which is that, which Leto just pointed out, and we were going to get to later, but she rushed towards it, which is that all these cases take place at a time where technology looked completely differently. And I want to save that for the latter half of this after talk to David, ask David Snyder a bit, who's clearly now back with us, about how the pandemic has changed the game for court access. And then I want to get into the technology question, which I think is just is needed. David, you and I actually spoke very, very early on in the pandemic, right when First Amendment Coalition was responding to how many courts suddenly were just closing their doors and citing public health requirements. Can you describe what court access looked like in this moment and how journalists were responding in kind of the early months of pandemic?
Yeah, very glad to. And thanks, Soraya, for the introduction, for putting this program on, and thank everybody who's watching as well. I mean, in a word, it was chaos. But let me sort of tell a story from last summer that I think highlights the problems that we confronted and tried to resolve over the course of the entire year. So in the summer of last year, as everyone will recall, there were protests, many of which had sort of devolved into violence and arrests that were prompted by the very death that we're talking about today. And so scores or maybe hundreds of protesters marching for Black Lives were arrested. And one woman by the name of Tanisha Brown went to court in Bakersfield, California, after she learned that her son, Avion Hunter, was arrested and injured in a clash with police in Bakersfield. And she wanted to be at his first court appearance. She went to the courthouse and she couldn't get in. The security said no one could go inside, even though there were arraignments and other criminal proceedings taking place. And so Tanisha said, and I'm going to quote from the complaint that we filed in Kern County Superior Court, she said, during this period of intense police violence and misconduct, it is really important that I'm in court to make sure that the police and prosecutors don't railroad my son, a young Black man who has never been in trouble. I want to be sure he doesn't accept charges or a plea deal he shouldn't accept. So she had no way to access the hearing physically. She didn't know of any other way to find out how to simply hear or see what was happening with her son. And we heard many, many stories like this over the course of our work last year. And many of those stories ultimately became the basis for our First Amendment lawsuit that we filed along with the ACLU against the Kern County Superior Court in Southern California. And if our experience is any guide, there were a lot of people shut out of court proceedings completely over the course of last year. Thousands, tens of thousands, I don't know. But we weren't able to do a systematic analysis, but our spot checks in courts in California showed that there were entire criminal calendars proceeding essentially in secret. And they were proceeding in secret because in some instances, the dockets weren't even available online. But even if you could find a docket and find a specific case that you wanted to see, you would show up to the court and they would say, sorry, we're not letting anybody in. There were many courts that had orders that specifically barred anybody from attending proceedings that weren't required to actually appear for the case, meaning lawyers or parties. So no press, no public. And that's understandable given the pandemic that they were limiting physical access, but there was no alternative. And so we worked very hard to remind courts all across the state that the First Amendment requires some ability to access proceedings. And so they had an obligation, we argued under the First Amendment, to provide some form of remote access. We argued for audio. We didn't think we'd have much luck persuading courts that they'd have to install, video access, because that's a much greater leap technologically. But we campaigned to remind the courts that some form of access is crucial. And federal courts in California responded fairly quickly. And we saw fairly quickly that proceedings were available by way of a free public phone line for the public and for the press to watch routine proceedings, both on the civil and criminal side. Although civil proceedings were shut down kind of across the board in many courts, especially at the beginning of the pandemic. The federal courts responded fairly quickly. State courts, not so much. As far as we could tell, there were many courts conducting proceedings with either no access, physical or otherwise, or with highly limited physical access. So maybe one or two people could get into the courtroom. So some good came from our campaign. There were a number of courts who, after being reminded of the constitutional issues, moved to quickly put in place telephone access, put a telephone number up on the docket that any member of the public or press could access. The quality of that access, I think, was in many cases left a lot to be desired, but many courts took the obligation seriously and put in place telephone access, and in some cases even video access. Other courts really held fast, even after being reminded of the obligation and being presented with kind of direct evidence that people couldn't get in. Direct evidence in the form of myself and my colleague Ginny LaRoe going to courtrooms, going to courthouses and trying to get in and being told that we couldn't do so. And then we asked, was there some other way I can view the proceeding? Answer is no. So even after hearing direct evidence like that, we heard back from some presiding judges that, there's no basis in fact to claim that they were conducting hearings in secret. So there was a lot of resistance. There was some movement toward providing remote access. And ultimately we filed one lawsuit over this in Kern County Superior Court. This is the case that I alluded to earlier. And the resolution there was a good one. The court took us seriously once we took them into federal court as a defendant, and we were able to negotiate a pretty well operating phone system so that folks from the public or the press know how to access the proceedings by way of phone. So that was a happy resolution in that one case. And then many, as I said, many other courts kind of moved fairly quickly to make sure that there was some form of remote public access. Across the country, a number of really interesting developments last year that I think are positive and that I hope remain in place even after court proceedings kind of return to normal, whatever normal may be and whenever that may happen. So we saw a lot of courts experimenting with live remote access for the first time, most notably the Supreme Court. 130,000 people listened to the first ever live stream of a Supreme Court oral argument, and some 2 million or so have listened to the recording. That's really remarkable. I hope it's not temporary. Similarly, in the lower federal courts, Congress authorized courts to lift restrictions on remote access for all federal trial courts. And that, again, is a tremendous development, which I hope is not temporary. So overall, there was sort of a paradox here. Physical access vanished almost entirely for many courts for a long time, while we saw this great ferment and experimentation with remote access. My hope is that once physical access is returned, this remote access remains a viable option, because remote access provides the ability for people to see or hear court proceedings, even if they're not in the physical location of the court. That's terrific for journalists. It's terrific for the general public. California for many years, and I think most states are similar, has allowed lawyers to appear by phone in a limited number of circumstances, and the courts deeply understand the benefits and the value of that. It saves clients a lot of money. It saves lawyers a lot of time. It's just more efficient. And so my hope is that by experimenting with and instituting these kind of remote access, the ways of accessing the courts remotely will continue, and we'll have the ability to not only get in physically, as the First Amendment requires, but to enter the courtroom virtually by way of phone line or video.
Yeah, thank you. You literally touched on all of the questions that I was going to ask you immediately after. I'm thinking of that, the woman who you mentioned who wanted to make sure that she was there, and that her son would not accept any charges that she thought wasn't fair. And I think it's, a lot of what gets lost in technical debates of court access is what justice means to feel like you, at the very least, are partaking in a larger system that can feel like it's moving past your pace or without any leverage. You don't really have a say in it, and it can seem, I think, like a cliche for people to, at the very least, get to listen or hear to something, at the very least to be there. But for that one person, you can see how important that was for her to be there, to be in the same room as someone who she cared about was going to be facing very serious trial. And I wanted to read a portion from the motion that you filed when you talked about, or trying to convince the court to allow cameras in this courtroom during this trial. I'll read it slowly for people. This is the very introduction. To frame the issue in the simplest terms, never before in the history of this country has there been a criminal trial like the one scheduled in these cases. While there have been big, important cases, few, if any, gave rise to social justice movements the size of what George Floyd inspired. None of them, meanwhile, went to trial at a time when a deadly pandemic had the country in its clutches, and when simultaneously the country had in its own clutches the technology to live stream a trial around the world. So while the state is correct that no court has recognized a First Amendment right to cameras in the courtroom, Its cited presidents lose their punch when one steps back to acknowledge that no one court has ever considered a situation quite like this one. How did the broader context, Lita, of this trial, specifically the summer protests against police violence, influence the judge's decision to allow cameras in the courtroom?
Yeah, I mean, I think the pandemic made all the difference here. It was the hook on which the judge was able to hang a First Amendment hat, saying that, unless we live stream this, we're essentially going to be having a closed trial because we can't open it up due to social distancing requirements. And so if you're looking for silver linings in a really horrendous year, the way the pandemic has forced courts to think about these issues, and as David S. was saying, to, necessity is the mother of invention. They haven't always done it well, but they've realized that they can live stream these things, they can put the audio on YouTube, they can do this, that, and the other, and it's a silver lining. And the stars aligned on this one from an access perspective. Stars are a catastrophe in terms of world events. Let's just acknowledge that. But from an access perspective, they align not just because of the timing of trial and the pandemic and the extraordinary public interest in this, right? I don't think you'd need to live stream a routine armed robbery because probably only 2 people want to attend that in the first place. But they also aligned in the sense that the defendants wanted this thing live streamed. And, I've never been a judge, but if I'm the judge calling balls and strikes in this case, my number one objective is don't create any issues for appeal. And I think he must have been thinking, if I move forward with this trial and I don't live stream it and I don't let anyone in, the defendants have an automatic Sixth Amendment structural argument, structural violation on appeal. And he just wasn't going to go there.
David, from your perspective and thinking about this in a kind of larger history, what do you have faith that these new technologies are going to kind of slowly be implemented? Do you think there is a strong argument that they actually can solve the number one issue that people were worried about, like live streaming a case avoids a lot of the chaos that Lita described that comes with allowing press physically into a courtroom, but ensuring the public access?
Well, I certainly hope so. Even back in Richmond newspapers, one of the reasons why Chief Justice Berger identified the fact that these proceedings should be open, he referred to, quote, the community therapeutic value of having open trials and access. And the fact that with certain trials in Richmond newspapers, it was somebody, I think, who had been tried 4 times. It was the 4th trial. Right. With certain legal proceedings, there is just vast, significant public interest. And, Chief Justice Berger also said, look, people don't demand infallibility from their public institutions, but they want to know what's going on, right? They should have an ability to hopefully gain a greater understanding and understand either how well or how poorly our governmental entities are working. And there's a lot of mystification, I think, about the judicial system. A lot of people who are not familiar with the judicial system are puzzled by it. And so any effort that increases public access to judicial proceedings, I think, should be applauded. And that's why, the work that Lita and David do are so important, because they're not just helping, let's say individual press entities, they're helping potentially millions and millions of people increase their understanding of how the judicial system works.
I want to move. Thank you so much, guys. David, Hudson. Before I want to move to open questions to the audiences, and please, everybody, please pose your questions in the Q&A, and we'll try to get to as many as we can. I do have one question for Lita, based on some of the more technical aspects of the funny things that occur when a court does decide to allow the press to film a case like this. Can you talk a bit about what had to change or what the court had to do, and also some of the confusing discrepancies between what they knew that the press needed?
Yeah, so when we were preparing for this panel, one of the things I told Soraya that I wanted to make sure kind of came out loud and clear is that you can, if you have a court willing to collaborate with you and plan with you, that is so valuable. I was involved in the Mohammed Noor proceedings. There was a different administration, sort of judicial administration in Hennepin County at the time. They weren't particularly willing to work with the media in covering that case. And I think the coverage suffered as a result. And I think it was a more chaotic scene as a result for the court. As the George Floyd proceedings, got going, I know, a number of media said, can you reach out to the chief judge and see if we can have a meeting? And I remember I was literally like revising my letter to him and getting ready to send it. And I got an email from the chief judge saying, can we have a meeting with the press? And we'd previously filed our motions to intervene, which is how he knew how to contact me. And I was just like, it took my breath away. I was like, oh my God, here's a judge who's like getting out in front of this, understands the press has an important role to play, and like wants to talk. And I'll never forget the first call we had. I mean, it was like mundane things from like, can you have reserved parking for us, to will there be a media room, to can we have electronics in the courtroom, all kinds of back and forth. And at one point the chief judge said, do you need a mini fridge to put your lunches in? And I was just like, who is this guy? I mean, it was just so gratifying to have someone who maybe didn't understand it all. And look, it hasn't been perfect. I'm not here to say that the court's been perfect in everything they've done, but to have someone who just cared enough to have the conversation. And so there's been, a number of Zoom calls between the chief judge, who's handling a lot of the logistics for this trial, and virtually any journalist who wants to attend or who I represent or know to invite. Like 2 or 3 of those leading up to trial, including one tomorrow, to talk about things that can be improved before opening arguments are on Monday, based on the experience of jury selection. And then I've personally had a number of calls with the chief judge to sort things out. So, there were very technical things about rewiring the courtroom so that Court TV could get the audio feed out to people, right? And they worked with Court TV on that. And the journalists were doing a lot of this on their own without the involvement of lawyers because they understand the technology. So yeah, I just can't emphasize enough. There are times you have to charge in with a motion to intervene and set the court straight. And we did that, but it can be much more efficient and productive if the judiciary is willing to educate the journalists and the journalists are willing to educate the judiciary, because judges are super smart people and they've been to law school, but they really don't know how the nightly news gets produced. And if you can tell them, that can make a big difference.
The specific example that I think you gave was that they had barred or said that there could be no still shots.
Yeah.
And they didn't understand, or the judges at the time didn't fully understand that once this video goes live and it gets spread, people will be able to just take that and screenshot from their laptop, and that things may appear in news sections outside of the bounds of what the TV producer actually made in the first place.
Right. Yeah, there's a restriction on the court TV technician to not zoom in on anyone's face. And obviously Derek Chauvin is the one everyone wants to zoom in on, at least for jury selection. So they can't do that with the video cameras. And the question, and everyone's been a little worried, well, can we take still shots that zoom in and can we crop them? And yeah, like the wire services, they might adhere to the spirit of that rule and only put the shot of the full counsel table on the wire. And the next day, the judge may see a zoomed in shot of Derek Chauvin. And, the Associated Press, Reuters, Getty, they're not to blame for that. And just explaining, we put these things out in the wild, Your Honor, and a lot can happen that we're not responsible for. Like, those are just important conversations to have. It just builds trust between journalists and the judiciary.
I thought that was very funny. I was imagined like not to accuse anyone of being old, but to accuse somebody of being old. I imagined like my grandmother or something, like who's maybe watching this now is to say something along the lines of like, how did they get that?
Right.
So I'll be mad that I said that. Well, okay, let's move to questions and answers. I see, Lita, I think you actually selected one that you wanted to answer first, but let me.
Yeah, while you're looking, I'll just say Mickey Ostreicher from the National Press Association asked about still photography. And the answer to that is the judge did not permit a still photographer in the courtroom. And that was really frustrating. But from a, given the nature, given what Minnesota rules say on cameras in the court, which is they're not allowed without everyone's consent. And then given the way the judge got around that by allowing live streaming, we didn't have a great legal argument to raise as to why we had a right to have a photographer in there. I think we could have had a sketch artist in the room, but the judge made clear that we had 2 seats, and either a pool reporter, the print pool reporter or the broadcast pool reporter would have to give up their seat if they wanted to give it up to a sketch artist. And at least so far, no one in the pool has thought that was a good trade-off.
Thank you. We have a question from Marilyn, and anybody who wants to answer can. She has actually 2 questions. The first is, if court proceedings are considered public for record sharing and transparency, do depositions also qualify as having the same public's right to receive?
I'll start by answering that. Our position would be if a deposition transcript is filed with the court, absolutely. If it's filed as part of a discovery motion to compel, I think the case law is a little thorny on that. But if it's filed with a summary judgment brief or a motion to dismiss, then absolutely you'd have a strong argument. At least in my home state, Minnesota, there's been litigation about just the deposition existing out there as discovery, but never filed with the court. Can you get access to it? And in Minnesota, the answer is probably not. I think that's a much harder question. But my position is if it's filed with the court, it's presumptively public, and someone better come up with a good reason not to produce it.
Yeah, just to piggyback on that a little bit, as Lita alluded to, discovery materials are there's generally not a First Amendment right of access to material that's purely exchanged by way of discovery in a case. Once it gets submitted to the court, then the game is changed entirely. And so, as Lita said, if a transcript were filed with the court, then I think the argument's very strong that there's a right of public access. As to the event itself, like, do they have to invite the public into the actual deposition? No, probably not.
I think that's probably very useful for journalists to know just generally, is that when things are filed, they're presumptively public. And I think maybe younger journalists who are getting in think that courts have some kind of secret possession over those documents, but knowing a general rule like that is really helpful when you're trying to report on court cases like these or like any others. The second question that Marilyn posed is, if and when online postings of depositions are challenged, judges may rule that they stay posted. In one instance, when a case was settled, the depositions were then quickly removed. Must the court honor the public's request to view these depositions even when those cases are settled? I'm guessing that basically in this case, when a case gets settled, so let's assume here that those court documents have already been filed, they're part of a case, but then that case gets settled. What is the status of all of the documents that existed that had been filed?
My position would be the same. If they're filed, or frankly, even if they're not filed, but they're in the possession, custody, or control of the court, then they're presumptively public. And documents related to settlements can be a little tricky under case law, especially if the court had some oversight over the settlement. Sometimes you'll see motions to seal surrounding that succeed. But if it once part of the file, always part of the file would be my starting position on anything in the court's possession.
And that touches on what Lita said. That touches on something that is a problem in certain areas of the country, particularly with, say, domestic relations cases involving very wealthy people, where there's an entire sealing off of court records. And we touch on that, as you know, in the teacher guide, the phenomenon of secret justice and the sealing of records. It's a problem in certain jurisdictions.
David, Lynette Thrower, because this is connected, someone from the audience, Lynette said, talked about, Mr. Hudson mentioned the mysticism surrounding how court proceedings are run. Could the public's general ignorance of trial proceedings potentially lead to an inflamed and angry public who will be scrutinizing and judging the behavior of the judges and attorneys, presumably without full knowledge of how courts are run? I guess I think the question here, and you guys talk about it, but maybe I'm getting this right, is I remember one thing that for example, the differences between second degree murder and first degree murder and third degree murder and manslaughter, people may look at that and think about only in terms of how many years someone goes to prison, but may not be as informed of what kind of evidence needs to be put forth in order to meet that standard or that charge. And I think that, of course, would inform how you think about justice, or you may believe differently about what kind of sentencing that person requires, but understanding what evidence is necessary to meet that charge or to charge someone with that crime is important. I think the problem is that there's kind of a cyclical issue where people don't have access to courts. They're presumed, they're kind of secret and hidden away. And then that makes people less willing or interested in the proceedings and all these terminologies, because why would they? They don't ever really get to see what happens there anyway. So things just seem like kind of obscure and unimportant. And then until you watch it, or then maybe courts get to kind of say, well, the public doesn't even understand how this works. And it's like, well, if you open these doors and there was a reason to fully understand it, maybe there would be a greater incentive to learn some of the technicalities in these cases. Do you guys see the questions? Do you see the question I'm referring to?
Yeah, there are going to be angry, unhinged people at the end of this case, no matter what. We just hope that with the transparency, there's fewer of them.
Yeah, let's see. Michelle Condon, I'm reading the more recent.
Yeah.
Lita, did you see something?
Yeah, yep. I agree. Like, knowing who your public information officer at the court is hugely important. And one of the things I've been trying to impress upon all the journalists involved in the Derek Chauvin trial is, can we please start by asking the question to the PIO and not bother the chief judge? Like, let's keep our powder dry and not be the boy who cried wolf, right? So yes, I completely agree. I do think it's important to recognize, though, that PIOs may or may not have a lot of authority depending on the court that they serve. And they may be sort of the messenger for a lot of stuff. And so it should be your first stop, but it doesn't always need to be your last stop.
Can you speak really quickly about who the PIO is and maybe a little bit of the background and what role they play?
Yeah, so the PIO, most courts have one, a public information officer in Hennepin County. His name is Spencer Bickett. If you're covering the case, you've probably spoken with him. And he, is the liaison to the media for the court. He is in charge of issuing media guidance documents on how coverage should look for the trial. You know, can they bring electronics into the courtroom? Where will the media room be? Will the media room have internet access, right? And when we ran into snags, which we have during jury selection, there were things that caused concern. I would reach out to him and say, we've got concern about this. Can you address it? Or if you can't address it, can we have a call with the chief judge? And if the chief judge feels like it's an issue for the judge overseeing the trial, let us know that, and we can, you know, make a formal motion. But yes, you should know that person. And, you know, in the best of circumstances, their goal is to work hand in hand with the media. And one of them said to me this week, you know, our goal is to make sure the court is not the story here. And that should be the goal. And I think it is for most of them.
Okay, looks like we're about time. I know Leto has to go, but if there's any last minute questions, I'm looking at the feed. I don't see any. You know, I think I'm pretty well. I've learned a lot. I've really enjoyed talking to you three, and hope that everybody in the audience also did. Of course, if you guys have any more questions or would like access to the teacher guide and are having trouble, please write to me. My email is sf152@nyu.edu. Otherwise, I really appreciate you guys for joining us for a long and really useful conversation, and hopefully this will be a continued partnership anyway. So good luck, Leto, and good luck everyone. Thank you so much for coming.
Thank you. I really
you,
learned a
Sarah.
lot.
Okay.